So off the record just for a second. Mr. Cross, you have a very strange. I know Flint County is a hotbed of UK basketball. And I've got a couple of extra tickets with Marlins. I thought you might know somebody.
Well, they'd be standing in line and wanting to go, but
But I just thought,
yeah.
is that not falling out? See,
Who do they play tomorrow night?
step over this one. Commonwealth versus James Hurst.
Yes, sir.
Commonwealth versus James Hurst. Are you James Hurst?
Yes, sir.
Good morning.
No, sir.
What is your last four digits, your social security number?
2119.
Okay, we're here on 22CR0013 and 22CR0038. Both of them are probation revocation. What does the Commonwealth have to say?
No, this is his motion for shock, Your Honor.
No. Wrong on the docket then. Okay, go ahead, Mr. Poindexter.
Your Honor, Mr. Hurst, pled guilty to theft by unlawful taking and trafficking a controlled substance in two different cases. He received 5-year sentence, probated for 5 years. He entered a long-term treatment program April 25th of this year, or I'm sorry, May 13th. And he made it all the way to phase 3 of ARC. I believe he had, how many days was it?
130 something plus days, 130 days.
Yes, sir. And he had injured his leg or his foot while he was there, and he felt that they weren't giving him proper treatment. And so he advised them that he was leaving, and then he did leave. And then he contacted ARC in Lexington. It's called ARC Anywhere, but it was in Lexington to see if they would go ahead and finish him out, kind of in an outpatient basis. The court here revoked him, and he's asking for shock probation. His father is here, who's 93. He was allowed in ARC to have a day pass Was it Saturday and Sunday?
I went home Saturday and Sunday
Okay.
for 10 hours each time.
So he was able to do that before he left ARC and was helping his father. And so he's asking the court to give him just one more chance. And
What's the
and he'll,
Commonwealth have to say?
Your Honor, he has had multiple violations, and I say without any hesitation that he's proven that he can't abide by probation. However, I would be agreeable if the court is, since he wants to take care of his father, I don't think long-term treatment's the responsible answer. I would be agreeable if he goes into drug court up in Bull County and can take care of his father. Maybe he could make drug court, and if he don't, he won't last long. So that'd be my suggestion.
and he would agree to that, Your Honor. He says that he's been sober the whole time since he got into ARC.
I've said.
Well, you've been sober, but you haven't been compliant.
Yes,
Okay, don't say anything else. You're in pretty good shape right now. So, but, you know, sometimes it's time to step back and punt, you know. Is that, where's your dad at?
Mr. Hurst?
You think you can keep this boy in line?
Do the best I can, sir.
Well, that's good enough for me. Okay, we're gonna send you to drug court. I'll refer you to drug
He'll
court.
have to get assessed here probably, and he'll have to be transferred up there before he can be released.
It'll take a little while to do it. So I'm gonna refer him to drug court, see if we can get him back up there. Keep an eye on him for me, okay?
I'll keep you right next door to me.
Okay, okay. Well, he won't get it out today, but it'll be a few days to get it lined up, okay?
Thank you, sir.
Okay, thank you. Okay, submit the order.
Thank you, Your Honor.
Yeah, Thomas O'Donnell.
Your Honor.
Good morning.
Good morning, Judge.
Is Mr. O'Donnell here? Or-
Should be.
I'll find this. See if Commonwealth versus Thomas O'Donnell, 22 CR 00103. You're Thomas O'Donnell, nor 1961, last four digits, social security number 6773. Let's do your first motion.
Your Honor, my
Your Honor.
motion today,
Could I interrupt?
I'm gonna take care of it. Yeah, let me just real quick.
Okay, go ahead.
Well, you got something about this or?
Well, I just want procedurally how we was gonna handle this. This is, I've not went back and counted the motions, but I don't know how long the court's gonna entertain motions in limine. If we're gonna have more, I would like to hear them all at one time and have a
Yeah.
cutoff date, because at some point in time, I've got to prepare for trial instead of hearing motions.
Yeah.
So,
I'll address it. I'll
Okay.
address it. I'm glad you brought it to my attention. Okay, what's this first one here?
Your Honor, the first motion is a motion to exclude evidence that was recovered from the Toyota Tundra in California that was registered to Mr. O'Donnell. There were areas in the truck that were sprayed with Blue Star, which is a blood detection chemical that luminesced. Those areas were swabbed and tested and came back as not containing blood. So I'm asking that evidence of the luminescing in the truck be excluded as irrelevant and prejudicial. In
Well,
addition,
let's do them one at a time here. Okay? If they have any results, you don't have any problem with it. There's no results of blood. you have any
well,
problem.
I actually do, because I don't think I've ever been through a trial of any significance where the defense counsel has said that law enforcement should have done this or law enforcement should have done this. And I don't know why I should be precluded from showing the jury that they did a thorough investigation in this case. I don't think it's gonna confuse the jury. They used chemical. They saw that it possibly blood. They tested it. It wasn't blood. You know, this is gonna be a complicated case.
How is that prejudicial to you?
well, Your Honor.
I don't understand why he'll even bring this up. I mean, there are enough things to
Well, it's in
bring
the
up.
test.
I understand.
That's the main issue, Judge, is that it's irrelevant, that it
I'm
doesn't
gonna
make anything.
overrule your
more
motion because
relevant.
it's not prejudicial to you. Go ahead. What's the next motion?
This is in the same motion. I have other items, Judge.
Okay, let's go.
The other is a paper towel that was found in the console of the truck. That luminescent was tested and was positive for blood. That blood was ran against the samples that the police had in their possession and did not, it was a male profile, didn't match Mr. O'Donnell, Mr. Harding, anyone connected to the case.
Okay, I'm gonna overrule you on that because it's not prejudicial. Go ahead.
Our basis is relevance, Judge, and if the court finds relevance,
sure-
then prejudicial, just to
make
be
sure.
clear.
Go with your next motion. Is that it?
That was my motion, Judge.
Okay, what's your?
And Judge, we have another motion limiting regarding firearms evidence and evidence of gambling. So there are three different categories of evidence, so we'll go through them one at a time. And the first item of evidence is a Panther 308 rifle that was recovered from Mr. O'Donnell's truck about 3 months after the alleged offense. And the issue with the firearms, Judge, is relevance. So in our motion, we cited two cases, Harris and Major. And in those cases, the Kentucky Supreme Court addressed guns that are being admitted into evidence that had been tested and precluded as the weapons used in the homicide. So when a gun has been excluded as being the murder weapon, the court has found then evidence of these firearms are
What do you have
not
to say about
relevant.
that?
There's two guns at issue, Your Honor. There's a 308 caliber rifle, which we have no objection to excluding because it's not relevant or prejudicial, I
Okay.
think, but I don't mind not using that. However, the 45 caliber pistol was formerly owned by Michael Harding. It was sold to him by Jay Gingrich. And the only way that Thomas O'Donnell could have gotten that pistol was from Julie Harding, who later committed suicide. And it's our theory of the case that even though that wasn't the murder weapon, that gun was partial payment for killing Michael Harding.
Well, it shows connect, well, it
It also shows a nexus.
Okay, I'm gonna overrule your motion on second weapon.
And then Judge, finally, there are references to gambling that were made during the grand jury proceedings. Detective Burton discusses Mr. O'Donnell frequenting casinos, and he speculates that perhaps there was some payment given to Mr. O'Donnell and it had been gambled away. But even during the grand jury proceedings, Detective Burton admits that there is no evidence to support that.
What do you have to say about that?
Well, Mr. O'Donnell frequented casinos quite a bit. In fact, he stopped at casinos in his route from California to Cumberland County and back. So those casinos will have to be mentioned in Ms. Wheeler's report on the geolocational data. Now, as regards the gambling activity, we know from investigation that Julie Harding had at least about $160,000 in cash on her, including other cash. And if that money was given to Mr. O'Donnell, that would be one way to dispose of it, rather where it wouldn't be traceable. So I think it all goes to that part of the case.
And Judge,
Wait,
there's no.
wait just a second. What do you mean it would be a way? to
Well,
dispose of it?
that's
Wait,
why-
let me ask my question.
Oh, sorry.
Most time I've seen, money disposed of at casinos, it's not traceable because you don't ever see it again.
That's correct. I said it's untraceable. And so if
Well, you
he's
don't
got,
know.
if he's supporting a gambling habit, that's another motive for getting this money from Julie Harding.
Well, do you know he has a gambling habit or that he just goes?
Well, we ought to have an hour.
Well, you might play nickel slots. You don't know what he's playing there. You know what I mean?
It's possible.
And Judge, in terms of the actual gambling activity, there's no evidence of a transaction. There's no evidence of him spending a substantial amount of money at a casino during this time. And so that kind of
Well,
evidence.
I would have to say that you need to you'd have to establish that to make it relevant. I think you got a good point there. If they show that he had a large gambling debt that was taken care of, or he had gambled a lot of money during this time period, it's not just speculative. It could be something that a reasonable person could, do. So unless you can lay that foundation.
But that's not going to prevent us from using these locations.
No,
Okay.
the locations are okay. Okay, now what else do you have?
Judge, I understand that as to the location, just for the record, our argument as to the locations was because they still invite these moral judgments about gambling in general, there's a neutral
Are
alternative
you
way.
living under a rock? Do you think anybody has any moral judgments about gambling? All these people are playing sports bets everywhere, everything, but they can do the locations. You can do the locations, so-and-so hotel or this or that, or where you stay. They don't have to identify them as casinos. That's fine. But I don't know. I guess you think because you're in a rural area that people don't gamble? Go ahead. What's your next motion?
Your Honor, that addresses the two motions we filed. The other issue that we wanted to raise again for the court has to do with the expert report from the Commonwealth related to this geolocational data that they're referring to. We still have not received that report, and I don't know if the court is willing to impose a deadline for the production of that so that we can prepare for trial.
Yeah, Detective Burton has either emailed or spoken with Elizabeth Wheeler. She works for the FBI, doesn't work for the Commonwealth Attorney's Office and the state police. She says she will have that report by the end of December. It has to be, we have to review it, and it has to be peer reviewed before it can be sent out.
Why is she saying the end of December? That, I mean, just because she can?
I don't know.
Who does she work
blames-
for?
I don't know, Mr. Burton talked.
Yes, sir. I spoke to her yesterday, afternoon on the phone, and that was just the timeline she was giving me.
What agency she work for?
She's an agent with FBI.
She's actually in Brooklyn, New York, I believe. Is that right?
Yes, sir.
She'll be traveling there to trial.
And the trial is when again?
April 27th.
So that's
I
4
don't
months.
think, I don't think that's prejudicial to wait to the end of December. If you don't have it by the end of December, you come back down here and I might try one of these, injunctive orders that these federal judges do to see if they pay as much attention to them as that. Okay, what else do you have?
That's it for Mr. O'Donnell.
Okay, now I think the Commonwealth makes a big valid point here. You know, y'all need to get, we don't need to be here every month on a new motion as far as to exclude things. I mean, you need to get, we can set a date and I'll give you everything that you want. But it's kind of like string betting. I mean, it's just an extreme of consciousness that things I don't understand. We don't need to be here every month doing this. You look like blank. Is it usual that you come every month to court to, on a case and nobody else is doing this? And I've been practicing for 50 years, almost 40 something years. And I've never seen these motions and limiting things spread out like this. I mean, what's the explanation?
Judge, we're preparing for trial, so we're filing relevant motions as they come up. And I mean, this is normal for us, so I don't really.
I
have a
don't doubt
response to
that. I had a feeling it's normal for you, but it's not normal for here. I'll continue to address your motions as you file them. But you ought to consider other people's convenience too, as far as these witnesses and other people and transportation of your client. And try to do as many of them collectively on particular days instead of doing it so often, okay? Just as a convenience and a courtesy to the Commonwealth. They've got other cases too, as you probably do. Thank you very much.
Thank you, Judge.
Yeah. I don't know what I swear those two are about. Y'all want to come around here? Okay, y'all might want to come around here. Yeah, and I guess we'll go to out of custody document. Y'all want to raise your right hand. You solemnly swear or affirm that you conduct your business as members of the grand jury of the Cumberland Circuit Court and keep all matters confidential that you hear in there, that you protect and defend the Constitution of the Commonwealth of Kentucky, United States of America. Do that. Thank you very much. Go with the bailiff. Commonwealth versus Mark Cruz.
He called the office on the 18th. It said-
You what?
He called the office on the 18th. He said that he didn't want them to be holding her for years.
Where'd he call from?
I've been talking.
Well, you want to put him in NCIC? Matthew Day. Matthew Day. That's true. You step back there, see, tell him he's been called. Beth Garman. Mr. Raymond. Commonwealth versus Beth Garman, 25 CR 0064. Good morning. What's your year of birth, Ms. Garman?
The year 73,
Yeah, and the last four digits, Social Security number.
3470.
You're here for the purpose of arraignment The grand jury of Cumberland County has charged you with operating a motor vehicle under the influence, fourth offense. Operating a motor vehicle while the license is revoked, possession of a controlled substance. Possession of controlled substance in third degree, failure to maintain insurance. Possession of controlled substance not in the original container, no registration plate. Failure to signal, careless driving. And failure to use a seatbelt. Do you understand what those charges are? Okay. You acknowledge the identity of your client received indictment, await formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. I'm signing a reciprocal discovery order that will get your attorney, the Commonwealth to give your attorney the information to help you prepare for your defense, okay? What is the negotiation day, Mr. Stockton?
December the 12th at 9 a.m.
Okay, you should be here on December 12th at 9 a.m. for negotiation and December 18th for your next court date. Both of them are part of your bond. We'll let you remain free on bond, okay? Thank you very much.
Thank you, Your Honor.
Yeah. Matthew Day. Commonwealth versus Matthew Day, 25 CR 0069. Are you Matthew Day?
Yes, sir.
What is your year of birth?
7/25/87.
Last four digits, social security number?
6558.
You're here for the purpose of arraignment. You're not represented by counsel. You don't have a lawyer?
I'm at Rutherford.
Okay, I'll continue that appointment. You have the right to remain silent. You're represented by counsel. The grand jury of Cumberland County's return indictment charges you with possession of controlled substance, first degree, second offense, possession of drug paraphernalia, possession of marijuana, operating a motor vehicle under the influence, and careless driving. Counsel, you acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Perhaps signing a reciprocal discovery order, which require the Commonwealth to give your attorney the evidence to help you prepare for your case. You'll be here on December 12th at 9 a.m. for a negotiation day, and December the 18th for your next court date. Both of those are conditions of your bond and will allow you to stay on bond, okay?
Thank you, sir.
Commonwealth versus Bobby Garman. Are you Bobby Garman?
Yes, sir.
Born 2001. Last four digits, social security number 1566.
Sir.
You're here for a pretrial conference on 25 CR 0051 and arraignment on 25 CR 0066. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with theft of unlawful taking or disposition. You understand what that charge is?
Yes, sir.
Mr. Bailiff? Counsel, you acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, enter plea of not guilty, reserving all pretrial conference.
Yes, sir.
Pretrial motions. Okay, I'm signing a reciprocal discovery order, sir, that requires the Commonwealth to give you all the information that you need to prepare for your case. You should be here on December 12th for negotiation day, December 18th, your next court date. Both of those are conditions of your bond, okay? Thank you very much.
Thank you.
Christopher Hill, active warrant, Christopher Hill.
Put him in CIC.
Put him in CIC. Barbara Johnson. Commonwealth versus Barbara Johnson, 21 CR 0024. Are you Barbara Johnson?
Yes, sir.
You were born in 1990.
Yes, sir.
Last four digits, social security number 7842.
Yes, sir.
You're here on a probation violation. What do
It's
you?
actually a review, Your Honor. She's in drug court in Warren
Yes,
County,
sir.
is that correct?
Mm-hmm.
And it-
Graduated this month, the
Okay.
30th.
I'd just like to withdraw my motion at this point. in time.
Okay. She can go back to Bowling Green.
Go back to Bowling Green and do well, and hopefully never hear from us again.
Well, I mean, you want her to come back
Well,
Yeah, not-
under
not
better
important.
circumstances, better
No, never
circumstances.
come back to this area.
Oh, well, I hate to, well, I don't know, I might reconsider this motion. She's slurring our area. Okay, we'll be on your way rejoicing.
All right, thank you.
Robert Kelly. Commonwealth versus Robert Kelly, 25 CR 0070. Good morning. Are you Robert Kelly?
Yes, sir.
You born in 1977? Yep. Last four digits, social security number 4514.
Yeah.
You have an attorney? Yep. Can you afford an attorney?
No.
Did you fill out an affidavit yet? Step over here and this gentleman will help you fill out an affidavit. April Nethery, active warrant, NCIC. Jimmy Otterson. Commonwealth versus Jimmy Otterson, 19 CR 0067. Are you Jimmy Otterson?
That's right.
Born in 1991,
Yes, sir.
last four digits, social security number 9087, correct?
Yes, sir.
Okay, you're here on 19 CR 0067 probation revocation. What we got?
Mr. Otterson has two problems, Your Honor. One, he had a use of meth and marijuana. And then there was a complaint of a vicious dog at one of his neighbors. The lady called the police. They had to pepper spray the dog. And it went back to Mr. Otterson's house, and then the dog warden came over and he was unable to obtain the dog. And I've got, Officer Hart here to testify about that at the court, but that concerns me. One, he had the dog here in town, and then two, when they tried to do something about it, he wouldn't comply and cooperate.
Your Honor, I believe at this point, he's willing to get rid of the dog. So,
What kind of dog is it?
It's a
Bad,
pit bull.
bad dog.
Well, the lady couldn't get out in her own driveway, and then she
Bad
called.
dog is a bad dog.
Yeah, it'd been some people's driveway, it wouldn't have left the driveway.
Yeah. Okay.
But Officer Harden can explain it.
What is the other? Well, they'll stipulate that there's a problem with the dog.
I think the other one, he had a positive test for marijuana and meth, and I think he's already been referred to SSC on that.
yeah. Yes.
What's he
Your Honor.
got? What's he got?
He's got 5 years on, let's see, trafficking in a controlled substance. Is the plea. And a possession. He had his total of 5 years.
Was this his first violation?
Yeah, he was on, federal probation. He completed that. Now he's still on state probation. But this has been his first, but the thing that bothered me was the non-compliances and the non-cooperation. We had this issue.
How much longer is he on probation?
I don't know if I'm.
Okay. 11/28/27.
So he's got a couple more years.
Yeah.
Oh, what, would you recommend that he participate in some drug program? Or you got any drug programs? He finish those?
Your Honor, the SSC evaluated him at a level for outpatient with interest of Burkesville. And that's what we recommended him to do.
Well, I'm gonna do something for you that doesn't happen very often for you, I guess. I'm fixing to give you a break. Okay?
So,
You get involved, you meet with probation parole officer, get in that drug treatment program. I don't want to see you back up here, okay? And so, you know, at least until 27, you need to live at the foot of the cross. You know what I mean? Be very careful, be compliant, cooperate with your probation officer. You know, he can be your worst enemy or your best friend. If he comes up here, you have some slip up or something, and he tells me, well, he's really been working hard and cooperate with me, gives me no problem. It goes a long way. Okay? So you meet with him. When can he meet with you about signing up that place up there? What do you?
We already have, Your Honor, whenever he first tested positive, I put him in front of the social service clinician. And she's already gave him all the information to get that started.
Okay, well, you go ahead and get it started, you know, into work tomorrow, or make show that you got an appointment, okay?
Done got contact with us.
Okay, okay. And, you know, you don't have to kill a dog, we just don't want the dog around here, right? Because they'll kill the dogs, you know, I'm a dog fan and pit bull, football, they're a strange thing. They can be very gentle around their owners, but they're very protective and vicious sometimes, you know, okay? Thank you very much. Ricky Purdue. Ricky Purdue. Commonwealth versus Ricky Purdue, 25 CR 0067. You are Ricky Purdue,
Yes, sir.
born in 1981.
Yes, sir.
It's the last four digits. Social Security.
1284.
Okay. You here for the purpose of arraignment. You have a right to remain silent. You're represented by counsel. The grand jury of Cumberland County has issued an indictment charging you with wanton endangerment in the first degree, 2 counts. And operating motor vehicle under the influence, reckless driving, being a persistent felony offender on 2 counts. You understand those charges? Counselor, you acknowledge the identity of your client received the indictment, wait for more reading and arraignment, and a plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order that gives your attorney, requires the Commonwealth to give your attorney information to help you prepare for your defense. You need to be here on December 12th for negotiation and December 18th for your next court date. And both of those conditions are your bond, okay?
Your Honor, if I could inquire about the bond conditions and see, we got a prohibition against driving, operating.
I didn't turn the license in, sir.
I just want to make sure that's part of the bond conditions.
Make sure it's on there, okay? Bernice Stearns. Bernice Stearns, yeah.
Yes, sir.
Bernice Stearns, will you turn your camera on?
It's saying cannot start video.
There you go. You almost had it. There you go. Commonwealth versus Bernice Stearns, 25 CR 0068. Are you Bernice Stearns?
Yes, sir.
You born in 1982?
Yes, sir.
Last four digits social security is 0513. You're here today for arraignment in 25 CR 0068. Can you explain for the record why you're not able to be here today?
Yes, sir. I'm at Skyhope Rehab in Somerset, Kentucky.
Yeah. Court ordered.
I understand, but we just want to know on the record that she wasn't treated any differently than anyone else. She asked for permission to do it, and we allowed her to do it. Okay. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree, failure to maintain insurance, failure to produce an insurance card. You understand those charges?
Yes, sir, I do.
Okay. Counsel, you acknowledge the identity of your client received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order, man, that requires the Commonwealth to provide your attorney with the information they have to help you prepare for your defense, okay?
Thank you.
Your negotiation day is December 12th and the next court date is December 18th. What are you gonna do about it? You gonna have her transported?
I believe she said that they would transport her.
Well, you need to do a
Yeah.
transfer order and send it to them so they have time and place on that, okay? And so if there's any problem, ma'am, with you being transported, you need to immediately tell your attorney about it, okay?
They'll let me, have family transport me if you want, if it's better that way for you all.
However your arrangements, fine with me, you're not in custody, you know, so if you make arrangements, okay?
Okay.
Okay, thank you very much. Ashley Stotts. Commonwealth versus Ashley Stotts. Are you Ashley Stotts?
Yes, I am.
Okay, this is 21 CR 00150. Were you born in 1984?
Yes, sir.
Last four digits, social security number 8511.
Yes.
You had a diversion. Diversion was revoked 10/23/25. What do you have to say, Mr. Cross?
Your Honor, the underlying charge Ashley had was back in 2021 for making false statement to receive benefits, food stamp benefits, I believe. She had $3,500 to pay restitution, paid that timely. She said absolutely no involvement with the court system. Since then, the only problem she's had was she obtained this,
I remember the
yeah,
case.
the medical marijuana issue. She continues to be gainfully employed here at a local convenience store.
Well, I believe considering the circumstance in this, and because, you know, the gray area and some of the things that she could very well, you know, I'm gonna give her, I will probate her sentence. 3 years,
That's fine.
3 years. You just, and it can be, you want her supervised or unsupervised? Let's be supervised for 6 months. Take a look at the supervision. If you do all right, we'll take you off that supervision, okay?
Thank you, Robert.
Okay, now she owe court costs?
She's paid for.
Okay, you meet with the probation parole officer, okay? Dale Warner.
Did he call this week also?
Yeah, I got confirmation. Part of his revocation motion that I filed was besides Matthews, he had an EPO, DVO taken out against him. He's in court today in that, I can't remember what county it is, Boyle County. And so I'm gonna pass the motion if that's all right with the court.
December 18th or just to renotice?
No, it's December 18th.
December 18th. Mr. Warren be notified, you know, if I'm December 18th. Elizabeth Watson. Commonwealth versus Elizabeth Watson, 24 CR 0086. You are Elizabeth Watson, born in 1970. Last 4 digits, social security number 8925.
Yes.
Okay, we're on a probation revocation. What's the Commonwealth have to say?
Amen, so. Your Honor, she was initially here because she had a positive test for meth. She admitted to altering that test, but with baking soda and pickle juice. Then you had her tested in court and it was positive for Suboxone. We had that labbed and the lab said it was negative for Suboxone, but it was possibly abnormal because it had a high pH. So after I got that lab result, I called Officer Garner and said, why don't you just call Miss Watson in at random and have her tested? And she was negative on 11/10/25. So that's the facts as I know.
Oh, how would you like to proceed with this?
Well, normally we revoke people that have altered tests. So I think if she's not revoked, she needs some type of sanction, at least for altering that test on September 22nd of 25. She did admit to it, but that doesn't excuse it.
She does acknowledge panicking and altering an initial test. I think some sort of reasonable sanction
Yeah,
would be.
yeah, I'm gonna sanction with 30 days. You're in custody of jailer.
Yeah. Okay, and it could have been a lot worse. Okay. Okay.
Yeah, I'm not gonna revoke her. Okay, Kenneth Woods. Commonwealth versus Kenneth Woods, 20 CR 0040. Are you Kenneth Woods?
Yes. Yes, Your Honor. My name is Clay Kennedy. I'm an attorney.
Yeah. You're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, we were here last month, I believe it was last month, and on this motion, and Mr. Woods had a positive test for cocaine on 9/26/25, but the court was concerned about a firearm charge. Evidently, what he did was, after he was taken off supervised probation in Shelby County or wherever it was, he's on probation, he went and tried to buy a gun through the internet, and he couldn't do that because he's on pretrial diversion. And that case is set for pretrial conference on 12/1/25, I believe.
In Bullitt County?
Yes,
Shelby.
Shelby County.
Yep.
And according to his attorney, that they're offering him a probated sentence up there, I think, is that right?
And 2 years probated was the offer they were gonna make. Judge Hugh apparently was on unsupervised for, I think, nearly 3 years.
But he's on a pretrial diversion here.
Yes, Your Honor.
And they're going, but if he.
Of course, he wouldn't qualify for another diversion
Yeah, and
there.
but if you enter a plea to a felony up there, obviously he's violated his pretrial
He
diversion.
has. Yes.
Well, I'm inclined to revoke his pretrial diversion here, and then whatever he gets up there, you'll do, they'll do a pre-sentence investigation report up there, correct?
Yes.
If y'all can just tag into that, and whatever they get him up there, we'll let this thing run with it.
Okay.
Does that sound like a reasonable resolution?
It does.
You know, you don't ever need to get around any firearms unless you get a presidential pardon. You understand that?
Yes.
You know, I mean, constantly, one of my fears is, and I think most judges are, is we let somebody slide on something like this and we pick up the paper and they've gotten a gun and done something. So, I don't see a reason to believe, there's nothing in the indication that that's gonna be you. But, I don't know, how much the probationary period up there is gonna be for how long?
The period, I don't know yet. We just had talked about the sentence.
Yeah, well, we'll hold this in abeyance, and if he enters a plea up there, they put him on a probationary period, we'll do the same thing down here.
Are you gonna go ahead and set him for sentencing here and revoke his diversion, or are you gonna wait?
I'm revoking his diversion today. Okay, and then what we'll do is, the probation parole can cooperate with them on the, you know, as they do the investigation up there, see if y'all can tag team it, can you do that?
I think it'll be two separate PSIs. I think it'll be like a supplemental on our end, because if we're waiting on them to do theirs first, they'll
Okay,
do the initial.
okay, well, let's let them do theirs first, then you do a supplemental, and then we'll schedule it for sentencing down, okay?
Okay, should we just coordinate that with your,
Coordinate with
Stockton.
Commonwealth Attorney.
okay.
Well, we don't know what day the sentencing will be on, but I guess we can schedule it for January the 22nd. Let's do that. That'll give some time. Do you think that'll be too soon for it to work through in Shelby County?
Well, I do have scheduled conflict on the 22nd.
We can do it on February 26th. if you want to.
That works. That should be fine.
Schedule his sentencing on February 26th. That'll give him more time to work. You need to meet with the probation parole officer there and give him information, okay?
And do it at 9 o'clock here on 23.
Yeah. Okay, that concludes everybody we have here?
Robert Kelly. Here's his name, Judge.
Robert Kelly for arraignment. Mr. Kelly, I can appoint you a public advocate, but I'm going to have to charge you, let's say, $750 or something. Is that agreeable with you? Yep. Yeah, it's parent order appointing. You make a little bit more money than some of these people do, but you know, you don't make enough money that I think you could go out and hire a private attorney. So I'll do it for $750. Yeah, right to remain silent. Grand jury of Cumberland County has returned an indictment charging possession of controlled substance of first degree, second offense, and possession of drug paraphernalia. You understand what those charges are? Counsel, you acknowledge the identity of your client, received the indictment, wait for more reading your own, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Have a negotiation day on December 12th, and the next court date is December 18th, and both of them are conditions your bond. I'll let you stick out on the same bond, okay? Thank you very much.
Thank you.
Now, that concludes the transported and out of custody. We're scheduled going with Barron County in about 13 minutes. So let's go off the record.
Here's the one.
Barry County. They just had come up here. Oh, well. I don't see Cumberland County on there, though.
He'll, maybe start back up. Okay, let's go on the record. Let's go, to Barron County first. Are you on that Barron County on there? Barron County? Okay, Commonwealth versus Timothy Jackson, 25 CR 0060. Are you Timothy Jackson?
Yes, sir.
Okay, were you born in 1984?
Yes, sir.
Last four digits, social security number 9460.
Yes, sir.
Okay, well, good morning. You're here on a pretrial conference. What's the Commonwealth have to say?
This case, along with these Monroe County cases, are set for mediation on December the 10th.
Yeah, 1 o'clock.
December what?
10th at 1 p.m.
Okay, well, let's just schedule it for this, we appear here on December the 18th. Mediation on the 10th, so you'll know how that came out, okay?
All right.
Great, thank you very much. Yeah. Is Roder Correctional Institution, are you on there?
It would be excused, Your Honor.
Yes, absolutely. Thank you for your cooperation. Is Roder on? Roder?
We will probably have to do.
Hey, can somebody, did y'all check, was there a order issued, Megan, on Roder?
Yes, Judge, there was I know it's right there. Same emails I always email there.
They just not fine.
I can email them back.
Good.
If I keep it up.
Probation parole, call up there to your brothers in correction to see if they've got an order on these, on Browning Bays, it's just a motion to forfeit.
That's correct.
I don't think that'll be a problem. And you got Robert Tabor. We'll come back to those. Adair County Detention Center.
This one second.
We're on, Judge. We're trying to turn the video on, but it says it's been disabled by the host. Oh, never mind. There it is. We got it. We're on, Judge. Good morning,
Good morning. Timothy Alexander.
Timmy.
Good morning. Are you Timothy Alexander?
Yes, sir.
Born in 1982.
Yes, sir.
Last four digits, social security number 5227.
Yes, sir.
If you're here on a probation revocation, what's the Commonwealth have to say?
Your Honor, Mr. Alexander has a 10 years on assault second, a 3-year possession for a total of 10 years. On 11/13/25, he was on site positive for meth. He has a new felony arrest and a new misdemeanor arrest involving alleged theft of a cell phone and strangling another individual. So, but they've not presented.
Is that what the felony charge is?
Yes, I can't remember. if it's the
Strangulation.
strangulation or the stealing that he allegedly stole an iPhone 14, so I can't imagine that wouldn't be a felony. And then he's also been charged with strangulation first degree.
It's in district court now.
It is. We've not even got the cases yet.
Okay, well, what I'll do is I'll take this in abeyance till see how those cases, Mr. Alexander, we'll see how your cases go in district court before we do anything to you, okay?
Yes, sir.
Okay, thanks very much. William Brooks.
Brooks.
Are you William Brooks?
Yes, sir.
Morning. This is 25 CR 005 and 25 CR 65 rather. Mr. Brooks, were you born in 1983?
Yes, sir.
Last four digits, social security number 7291.
Yes, sir.
You're here for a purpose of arraignment. One of your attorney is here. You have the right to remain silent. Grand jury of Cumberland County has returned an indictment charging you with forgery in the first degree and theft. I'll take your disposition, Mr. Bailiff. Present that counselor, do you acknowledge the identity of your client receiving indictment away from Regan Raymond, enter plea of not guilty, reserved, I'll pre-trial motion.
Yes, Your Honor.
I'm gonna sign a reciprocal discovery order here that requires the Commonwealth to give you evidence to help you prepare for your defense. Mr. Stockton, does Commonwealth want to include all of these,
He's,
pre-trial
he's
version?
currently in drug court on 25 CR 5. And he has the new case, so I'd ask for negotiation. I don't know that he'll get to stay in drug court or not.
Negotiation day on December the 12th, the next court date on December 18th. And you'll need to prepare transportation orders. I guess you'll hear from the drug courts.
Yes.
Okay. Okay, thank you, Mr. Brooks.
Thank you.
Yeah, I'd be interested in to see if this occurrence happened before his plea, if predates his drug court.
No, the only question was he was in drug court, I think, at the time. And I can't remember if this happened before or after he got out of rehab. I'll have to check
That's
in.
what thank you very much. Commonwealth versus Jimmy Clark. Are you Jimmy Clark?
Yes, sir.
Good morning. We're here on 25 CR 0063. You're here for sentencing. Mr. Clark, were you born in 1987?
Yes, sir.
Last four digits, social security number 3975.
Yes, sir.
You had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Is it substantially correct? Is it substantially correct?
Yes, sir.
Counselor, is any reason this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty, possession of controlled substance, first degree, 2 counts. The defendant shall receive a sentence of 2 years on each count to run concurrently for a total of 2 years, probated for 4 years supervised. He should be assessed and follow the recommendations of the social service clinicians who credit for time served. Shall have full employment or 30 hours community service if he's not employed. What's the court cost in this case?
$190.
$190. You need some time to pay that.
Yes, sir.
I'll pay it at $40 a month. The first payment due in 30 days from today. When can he meet with probation and parole?
Tomorrow morning.
Today.
Your Honor. Tomorrow morning.
Okay, I'll let you out in the morning at 8 a.m. and you go straight over to the probation and parole office in Farmview, okay?
Okay. Thank you.
Very much. Melanie Connor, Commonwealth versus Melanie Connor. Are you Melanie Connor?
Yes,
Hey, here. Yeah, good morning.
Yes, sir.
You were born in 1982.
Yes, sir.
Last four digits, social security number 0634.
Yes.
And we're here on 20 CR 00033, a probation revocation. What does the Commonwealth have to say?
Your Honor, she has a 3-year sentence on trafficking and controlled substance first. She had some probation violations. She entered and completed the drug court program. Then when she came back out on probation on October the 27th, 25th, she admitted to smoking meth. She purchased a detox drink, passed the test, and also was used Suboxone.
Yeah, and we stipulate, Your Honor, we just ask that the court consider sending her to a rehabilitation center in lieu of revoking.
I would think that she probably needs to be revoked and maybe come out on shop if she doesn't make parole in the rehab myself after somebody's already been through drug court.
Well, I think that's a good idea. I think go ahead and revoke her probation, and then as soon as she's eligible for a shock probation, I want you to get a hold of Commonwealth and see if you can convince them that you have a treatment that would be appropriate for her. I'm concerned about the health and well-being if she stays out. So your attorney will be up to see you soon to see and we'll tell you how long you have to be there before you're eligible for shock probation. I don't even know whether they'll transport you out of there before you're eligible or not, okay? Okay, thank you very much. Alfred Casillas for sentencing.
That's the only judge.
Good morning. Are you Alfred Casillas?
Yes, sir.
Were you born in 1985?
Yes, sir.
Last four digits of your social security number 5305.
Yes, sir.
We're here for sentencing in 52 CR 0052 and 25 CR 00033. And there's a motion to forfeit all of them. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Substantially correct.
Yes, sir.
Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
On 25 CR 0033, upon plea of guilty to possession of firearm, a convicted felon defendant shall receive a term of 5 years to serve. On 25 CR 0052, the defendant shall receive a sentence of 2 years on operating a motor vehicle, pay a fine of $200. The sentence is to run consecutively with a 5-year sentence and 25 CR 0033 for a total of 7 years. What are the court costs?
For both cases, it's $1,015.
Okay, both cases are $1,015. I can waive all except the DUI, correct? So what would it be on the DUI?
Take that off.
Do you have the DUI document signed by?
I believe so. Is it in this file?
No, I don't think it. I got it.
I'll get-
It's not, it's not signed.
How much?
Sorry, I was. $390.
What were the others for?
The DUI, there's a $320 DUI fee, well, that will be $425. And then $200 fine,
And what?
a $200 fine that goes along with the DUI.
How did it get to be 1,000?
Court costs some of them, yeah, he has other cases, so.
Okay, I'll just waive the court costs on both of them. You'll still have to pay the DUI fines. And when you get out, you can start paying those for $60 a month, okay?
Yes, sir.
Okay, thank you very much.
All right, thank you.
Barry Gibson, motion for it was not opposed, so I'll enter.
Okay.
Barry Gibson, good morning.
Good morning, Your Honor.
Are you Barry Gibson?
Yes, sir.
Okay, were you born in 1969?
Yes, sir.
Last 4 digits, social security number 9632.
Yes, sir.
You're on a pretrial diversion revocation motion in 22 CR 0037. What's the Commonwealth have to say?
Your Honor, I've got the KSP officer subpoenaed today for hearing, and I spoke to Mr. Rutherford about the allegations. I told him we could get him the report today or tomorrow, so he go over with Mr. Gibson. So he's asking we can do this next month. That's all right.
What were the allegations?
Well, it's, there's sexual abuse,
Okay,
videotape,
okay,
and
all
things
right.
of that nature.
Let's set it over to December 18th. Your attorney is requested to have some time to look at this information more, Mr. Gibson, so he can prepare your defense. So he'll be up to see you. And we'll schedule you for December the 18th, okay?
Okay.
Thank you very much. Scotty Lake. Come up first, Scotty Lake.
Yeah, just a second here. You see that?
He's at the Class D facility, Your Honor.
Okay.
Go ahead. Go ahead, he's in.
Need to get the camera on.
Camera's on.
Well, the camera might be on, but the picture's not up.
Wait a minute. Well, yeah. That's why he might be kicked off. So, you know. There you go. Can y'all hear us? No, that's on them.
Well, let's go ahead back to the jail.
Okay, can you hear us now?
I can hear you, but I can't see you.
Okay. What's going on?
There you go. He's good.
There you go.
Nope.
All right, good deal.
No. Still can't see you. Let's go ahead with the rest of the docket. Maybe the Class D facility can get that working in a few minutes. Mary Beth Stalker. Mary Beth Stalker. Are you Mary Beth Stalker?
Yes, sir.
Morning.
Good morning.
Were you born in 1983?
Yes, sir.
Last four digits, social security number 2212. We're
Yes,
here
sir.
in 23 CR 0038 for pretrial diversion revocation. What's the Commonwealth have to say?
Your Honor, we have another case on this topic that's going to grand jury today, so we'd ask for a negotiation day in the next pretrial.
Okay, the negotiation day. Ms. Stalker, they said they've got another grand jury case that they might be considering today. So we'll schedule you for a negotiation day on December the 12th and the next court date on December 18th. That way you can get all this wrapped up into one negotiation, okay?
Okay, thank you.
Thank you very much. Brian Thompson. Brian Thompson. Are you Brian Thompson?
Yes, sir.
Good morning.
Good morning.
That's 20 CR 0066. Mr. Thompson, you were born in 1980.
Yes, sir.
Four digits, social security number 4324.
Yes, sir.
You're on probation revocation.
Your Honor, this is an old case because Mr. Garner tried to have him transferred to Tennessee twice. That was never completed, and he got into trouble in Tennessee. And I spoke with Dan and Carbon, I think her last name's changed now. And she is a probation parole officer stationed in Cookville. Mr. Thompson has 2 8-year sentences from Tennessee, including manufacture and sale of methamphetamine, that he's on parole, and he'll be on parole the next 2 years in Tennessee. And I don't want to have Mr. Garner to have to do a transfer again or revoke him and put him in jail up here. I'd rather just send him back to Tennessee if that's the
What's the
case.
charge up here?
Possession. So you can either revoke him, give him a 3-year sentence up here, or send him back to Tennessee and kind of ban him from the state.
Do they want to extradite him?
Yeah, they'll take him back. If he release him, he's to report back to Miss Harvey.
I'm not really inclined to release him and depend on him.
I don't know that Tennessee will pay the money to come and get him, to be honest with you, because he's already on parole. They don't have any
Maybe you
violations.
should take him down there
And dump him at the line.
could you see if they'd be willing to pick him up at the line or something, or?
I can inquire, Your Honor.
Yeah.
Yeah.
What, I mean, usually with 8-year sentences, they would want to
Well,
extradite.
he served his time already. He's out on parole on 8-year sentence. That's the reason it took us so long to get him. Tennessee made him serve. I think he served about a little over 2 years, according to what she told me. So he's done with them, other than he's got 2 years of parole left. Basically, the way I looked at it, he killed this case when he served out down there. But if you want him to serve this time,
I don't want anybody to serve. You know what I mean? I
Yeah.
want everybody to have a great life. So, Mr. Thompson, if I'll let you out up here, will you go down there and report to your parole officer?
Yes, sir.
If you don't, you're
I
gonna get
know.
some up here. You understand what I'm saying?
Yes, sir.
Everybody needs a break sometime in their life. You're fixing to get one right now. You get
I
down
appreciate it.
on parole, get you a job, look up every day and thank God that the freedom you have, you know?
yeah, and I think she also told me that your certificate for your rehab or whatever your program you're going to attend has been approved too. So when you get down there and report, you can do that.
Okay, I'll let you out. When can you have somebody come pick you up?
All right, thank you. Yes, you question. Do what?
When can you have somebody come pick you up?
In just a few minutes.
Few minutes.
Yeah.
Well, okay, well, I'm gonna release you on this. I guess he's withdrawing his probation revocation motion. I'm holding it in abeyance, so we'll get a release, so, you know. Okay, good luck to you, man.
Thank you.
Yeah. Rebecca Thompson. Rebecca Thompson.
Good morning.
Good morning. Are you Rebecca Thompson?
Yes, I am.
25 CR 007. Ms. Thompson, were you born in 1980?
Yes, sir.
Last four digits, social security number 9406.
Yes, sir.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is it substantially correct?
There's
Yes.
one issue, Your Honor, that
Your
her
attorney
last,
says there's an issue to be corrected. What is that?
her last name is incorrect on it. It's, that was her former last name.
Okay. Thompson is her name now?
Yes.
Yes.
Well, that's how I have it on the docket. So make sure that the pre-sentence investigation report changes Fulton to Thompson. Okay? Did you catch that?
Yes, sir.
Okay. Is there a reason why she should not be sentenced?
No, Your Honor.
Upon pleading guilty, possession of controlled substance, first degree, the defendant shall receive a sentence of 2 years on each charge running concurrently for a total of 2 years. Probated for 4 years, supervised. She should be assessed and follow any recommendation of social service clinicians. Receive credit for time served, should be gainfully employed to do community service. What's her court cost?
$190.
You got $190 court cost. I think you probably need some time to pay that.
Yes, sir.
First payment would be $40, 30 days after you're released, $40 a month, you pay it full, okay?
Okay,
We'll,
thank you.
When does she need to meet with probation parole?
One more, Your Honor.
I'll let you out in the morning at 8 o'clock, go straight over to the probation parole office, okay?
Okay, thank you.
You're welcome. Good luck to you.
Thanks.
Christopher Toole. I'm over Christopher Toole. Are you Christopher Toole?
Yes, sir.
21 CR 0083, Mr. Toole. Were you born in 1978?
Yes, sir.
Last four digits, social security number 5822.
Yes, sir.
You're on probation revocation. What's the Commonwealth have to say?
Mr. Toole graduated from the specialty court program in Clinton County. He was placed on probation. On May the 31st, he admitted the use of meth. On October 28th, he was on-site positive for meth. He denied use. It was sent to the lab and confirmed to be meth. So I'm asking he be revoked.
So we stipulate, Your Honor.
Okay, we will revoke the probation. And is he eligible for shock probation?
Well, he would be in 30 days, yeah.
Okay, we'll take a look at him in maybe 60 days from now. Mr. Toole, you know, you had it licked. And you fell off, so I'll go ahead and revoke the probation, and your attorney will keep in contact with you 60 days or so. We might try to take a look at some in-house treatment for you or something, okay?
Okay.
Okay, good luck to you.
Thank you.
Have anybody else there at the jail that we haven't seen? Scotty Lay, did we see Scotty?
Not yet. He was at the Class D.
Scotty, have you, they got the Class D? Carson, we always like to see you, but are you involved in the Scotty Lay case?
No, sir, I was involved in the Chris Toole case.
That's over with, do you?
Yeah.
Yep, I was getting ready to ask you if I could be excused, Judge.
You can be excused.
Have a happy Thanksgiving.
You too. For some things you be excused, other things I'm still holding against you.
We can't get the camera up. You don't know what's going on with it. We got the volume, but not the camera.
We'll try to do it without the camera, okay? Commonwealth versus Scotty Lay, 22 CR 0018. Scotty, are you there?
Yes, sir.
Were you born in 1967?
Yes, sir.
Last four digits, social security number 2701.
Yes, sir.
We're on 22 CR 0018, motion for shock probation. What do you have to say?
Yes, Your Honor, his sentence began July 31st, 2025. Since he's been incarcerated, he's completed an anger management course. He's currently enrolled in MRT. I don't think he's had any disciplinary issues. Every chance he gets, he goes and he'll help at the senior center as well.
What was the original charge, Mr. Stockton?
It was possession. He had a 2-year sentence. I'm wondering if he's had any treatment of any kind.
I don't think there's been anything offered as of yet. Now, whenever he was revoked, he had just started in an IOP program. And that's what he wants to do, is get back out and do an IOP program.
Where's he gonna live at?
He's gonna live with his girlfriend, Sarah Page, who he also takes care of. She has some health issues.
What county is that?
It's in Tennessee.
Oh,
Clay County.
Clay County.
Yes, sir.
well, it'd have to be, if he's shopped out, it'd have to be transferred. He'd have to stay here. People don't realize they've got to stay here until Tennessee approves the transfer.
Yeah, I spoke to him about that.
Yeah.
Scotty, if I shock probate you, you're gonna have to stay here in Kentucky until Tennessee accepts supervision of your probation. Do you understand that?
Yes, sir. They transferred it down there this last time, you know.
Well, I have to do it again.
Yeah.
Okay.
Where are you gonna live you got a place to live in Kentucky if I shock probation?
No, sir. I don't know anybody here.
So that's the problem we've got.
I mean, my probation officer, he came to the house here about a month ago down there, and he told Sarah, my girl, that he had no problem, seeing me again, you know. Derek
Wait
Finley.
a second.
Okay.
Mr. Governor says he can work with him when he gets out, so he can go to Tennessee.
Yes, that's fair.
Where is he, if I let him out today, does he come see you?
Yes, Your Honor, if since he's a returning resident of Tennessee, he has to come straight to my office, do the paperwork, and then I can transfer him immediately on a pass. If they don't accept it, he has to come back.
Okay. Well, I'm gonna let you out in the morning, Scotty.
Okay. Thank you.
I don't want to see you again on any of this stuff. You understand what he's gonna do? If you get out in the morning, you go straight over to probation parole office. He's gonna give you a pass to go down there and see if you can meet your probation officer down there and see if they'll accept you, okay?
Okay. Can there any way I can get a ride from Adair County down to Burkesville?
We don't have a concierge service.
Well, I understand that.
Yeah.
I'm just making sure before I.
But I think
He needs to go to the Columbia office. He's
the Columbia office is where you need to go.
Okay.
You go to the Columbia office, probation and parole.
I won't be able to
Okay.
do a release on him because he's a state inmate, so if you want him out by the morning, I'll need a short probation order, and I can short probation by this afternoon.
Okay.
Okay.
Okay, I'll enter the shock probation order today and they'll send it up there to the jail.
Okay, somebody will have to tender it.
I'll tender it.
Yeah.
Okay, thank you. So what you're saying is you don't have anybody give you a ride back down to Burkesville?
No, sir. I mean, I probably can, but just in case I could.
We don't have anybody, our jailer is already gone back up there. We can't get you the order in time, so you'll need to make arrangements for somebody to come get you, and it'll probably tomorrow.
Okay.
Probably tomorrow, okay?
Mr. Governor says he can walk to probation parole office. It's closed.
Yeah. So when you get out tomorrow, you walk over to the probation and parole office and have somebody pick you up there after you do your paperwork tomorrow, okay?
Yes, sir. Thank you.
Okay, good luck to you. Is there anybody else in Adair County that we haven't seen? Okay, now did we ever hear from Roder?
He's not in, Rotor as far as I can
Well, I
tell.
go over and have a word today. Can I go back?
Adair County, y'all are released, y'all are excused, both.
Same maybe in Barron County Jail, Mr. Bates.
Who, Robert Tabor?
Now, Robert Tabor's probably in Roder.
That's the only one we have left, isn't it? Robert Tabor? Robert Tabor?
Yeah, we probably need to pass him anyway, because Miss Costello's his attorney, and she's on leave.
Okay,
Well,
well,
I
let's,
represent him for now.
Okay, I've got my paper.
well,
I'm sorry. Thank you.
I think
let's this was a pretrial conference. What is his charge?
Ray, sexual abuse.
Well,
We just now got the records for them from DCPS.
well, let's go ahead and schedule him for negotiation. That's not prejudice in any way as far as not be, so do a transportation order for him. Schedule him for negotiation for December the 12th. And December the 18th is his next court date, and that believe Bronny Bays.
Judge Bronny is in Barron County, and they are going to get on something.
Oh, that's good.
They're what?
Bronny is in Barron County, and I'm told them they're going to get on something.
Okay. What is this a forfeiture on?
It is a list of things. It's ammunition, guns, vests, AR-15s, flashlights, things, paramilitary gear. And it either needs to be forfeited into the state police or returned to the state of Betty Williams,
Or return to who?
the state of Betty Williams. I'd say a lot.
Yeah, the case is on appeal. Let's just pass over this. The case is on appeal. So we'll just pass over that. Tell Barron County that we just passed over it, okay? Okay, is there anything else on the criminal docket? Is it waiting for the grand jury? Let's go off the record. If the host will open up the video.
Hey.
Here we. Okay. Mr. Bays, can you hear me? There was a motion on today to forfeit some of the things that were seized when you were arrested, but I was informed that your case is on appeal. So I won't go ahead and forfeit anything until we find out what the resolution of your appeal is. Okay, is that all right with you?
Yes, sir. Yep.
Okay, thank you very much, Barron County. Y'all are excused.
Thank you so much. Have a good day, Your Honor.
Thank you. Everyone have a seat. Okay. Barn Grover versus Marion. Hello.
Oh.
Mr. Cross, were you involved in this thing at one time?
What's the style of it, Your Honor?
Barn Grover versus Marion?
I do not believe so.
Well, they had you on the
I've been involved in.
docket sheet. Okay.
Many of them. Sometimes I don't recollect.
Okay, I understand that. Yeah. Says on here supplemental GAL report file 10/22/25.
Yes, there was a motion for custody here. Mr. Clark was jail. You asked for him to do a supplemental because it had a few months.
Yeah.
And he stopped.
Getting jail on Mr. Gardner supports returning the minor children to their mother. Does the cabinet have any objection to that? I wondered they.
No. Miss Mary was incarcerated, that's all her home.
Yeah.
Okay.
And y'all still don't have attorneys involved?
No, sir.
Well, I don't know who's gonna prepare the order. Usually the failing party does, so.
Originally, you told us, last
Do
time.
what?
Said originally, you told us the last time we were here, we wouldn't have to appear again. You would just sign an order and, but then your secretary called and said we.
I don't have a
need to
secretary. I have a
Well, somebody
staff,
from the
I have a
courthouse.
staff lawyer, so.
be- Somebody called from the courthouse and said we needed to come in. You were just waiting.
Well, you want to completely turn custody back over to the mother? Are you,
Yes, yes, sir.
so you have a job now?
Yes,
Where
sir.
are you working at?
DoorDash. I'm a dasher and she's got her own
Wait
place.
just a second. I'll call on if I need you to tell. Okay. You have a separate household set up and everything?
Yes, sir.
Where's that located?
It's in Albany, Kentucky.
Okay. Well, we'll check and see what the last order was. See the GAL report there.
You just want the order concern custody.
Has there been any supplemental or is it modified custody in the file since then?
Now, there was a contempt on the dad, but
Yeah.
I haven't paid, yes.
Does the father have any?
Are you to his custody?
Yeah. We have Megan in this case here, that we got in front of us here. The GAL recommended returning custody back to the mother, okay? We're gonna have to draw them an order up to do that. I was just seeing if there were any other conditions in between then that would have to be modified by the order.
Well, there was originally an order adopting the DRC recommendations, which I believe gave the respondent in custody. Or the petitioner custody. And then, in August of 2020, and then in September of 2020, there was an order altering, moving, or vacating that order, and maybe intervening respondents. So that's the last one. So it'll just have to be break the custody order.
You've had the children for how long? 4 years?
I've had them a total of 7 years. Originally, Danielle had given me a paper.
I don't want to go into the detail. I just
I've
asked you
had
for
them total of
7
7
years.
years, yeah.
Well, what I'm wondering is, whether we need to make findings and all that sort of thing to do that, or just need to do a simple order?
I think it's not contested, so.
Yeah. Well, we'll do a simple order.
Thank you.
We'll do a simple order. It's unusual because of the length of time. That's what kind of confuses me, that under this temporary order because of her incarceration.
That's kind of why you wanted the supplemental.
Yeah, and that's why we got the supplemental GAL, but, okay, we'll enter it. It might be a few days that you'll have to take a place in the queue, you know, on the line to get this ordered out. Okay,
Thank you very much.
take care of those children.
I will.
Thank you so
much.
Okay,
Thank you.
okay. Lacoste, Smith Carver versus Brett Carver.
Good afternoon, Your Honor. This is Chris Davenport. I'm on Zoom.
Yeah.
Good afternoon, Judge Jonathan Lanham on behalf of Mr. Carver.
Has all the discovery been finished and complied with it? I know that's been a continuing issue in this case.
Judge, I've received supplemental responses from Mr. Carver's attorney. I believe it's probably consists of all I'm going to get out of the case. I think what you're going to end up hearing at trial is he's going to claim that other properties and assets don't exist. Ms. Carver's going to claim that they did exist and they should exist. So those will be dissipation claims. I think we're at the position we need to get a trial date in this. I think the only thing outstanding needs to be done on our end is, now that he's given me all the responses he's going to about the assets that he has and what's happened to them, those assets she believes that have been dissipated will need to be valued. If I present proof of dissipation and don't value those, I mean, Your Honor won't have a whole lot of options to do about that. So I think that work can be done before we can probably get on your trial docket anyways. I know the circuit is very good about, you don't set trials a year out. You set them weeks, maybe months out. I think this case would probably be good to set for maybe February or March. I would defer somewhat to Mr. Lanham on that.
Your Honor, I would generally agree with that. I think it's possible. I don't know the scope of of how much agreement we might come to in terms of stipulating values on some of the assets that are involved in this. I don't know that we really tried to have that conversation much in the past, but we probably could come to alignment in terms of division, especially assuming that we're going to auction the bulk of those assets anyway.
Yeah.
But with respect to the trial date, I think February or March would be appropriate.
And to be perfectly transparent with the court, my client's position is going to be that all these farm assets and equipment should just be sold. We have discussed that on the past. Mr. Carver may take a different stance on that, but if so, that he'll need to present valuations of things he doesn't want sold. What I'm talking about are valuations of items he claims no longer exist and therefore cannot be sold. So that's where I'm coming from.
Well, you know, before we start a trial on something like this, you know, I want to reduce to some memorandum or some listing exactly what I'm going to have to hear testimony about, what I'm going to have to find, what the issues are. I'm not going to sit here for 2 or 3 or 4 days and count spoons and bring things up and make a list. So what we'll need to do is we need to have identifiable assets that we have And then whether or not there's a challenge, there's a challenge as to whether they're marital property or not. You know, or, and then the ones that Mr. Davenport, you claim have been dissipated. And so we'll have a list of things and we'll take proof in an orderly sort of way, because it could take forever if we just list down through here and I don't have something to follow. Do you think y'all can come together on some kind of list like that to the facts I'm supposed to find?
Judge, I think I could, and I completely agree with what you're saying. And I guess I would couch that in terms of a global trial memorandum that we
Yeah.
would present to your honor. And I think I could, and again, I'll have to get those claimed dissipated items appraised so I can present those values in that memorandum. I think I can present that memorandum by the end of January. And if counsel could do likewise on his end, and then, you know, if we're looking at a trial date in February or March, that would give both sides time to digest each other's memorandum as well as the
Yeah, we
court.
don't have to agree. There doesn't have to be an accord or agreement on what's in there. It's just actually as a kind of articles of disagreement.
Sure.
Right.
Okay.
But
Okay.
I
Well,
find when all parties lay their cards like that out in the memorandum, it does increase the chance that we can agree on some things. Maybe not everything, but we can maybe narrow some things down.
let's look at the week of February the 23rd, 24th. Let's set the 24th and 25th as the days, okay? 24th and 25th.
Your Honor, I'll be out of town the 24th. I would be available the 25th. And
I don't think we can do this in one day. Do you think we can do this in one day?
No, I think it probably takes two, Your Honor.
Okay. What about February the 9th and 10th? Or the 10th and 11th? Let's say the 10th and 11th.
Judge, I think that would be possible.
I could do the 10th and the 11th, Your Honor.
Okay. Okay, and I would say that this list should be presented to the court by January the 22nd. That's the rule day in January. And that way, if there's any problems as far as getting the trial memorandum together, we can settle it on that day. Does that make sense?
It does, Your Honor.
Okay, well, thank y'all very much.
Thank you, Judge.
Your
Have a good
Honor,
afternoon.
Your Honor, could we address a holiday schedule for the child?
I don't think I have a motion on that, do I?
We don't. In the past, we have discussed it, and it has not been able to materialize in the time that's been possible. And so, if we could just have a very brief instruction as to who can be with the child for the holidays, that would be really productive.
Your Honor, I must object. This is like the third holiday these parties have participated with each other during a divorce, but my client's not with me. I had no notice of this, and we specifically set this date just to get a trial date. That's why I'm not in front of Your Honor right now with my client.
Yeah, we're back now. Let's, if your case is not up right now, turn your camera off, please. I told Mr. Carver he could go ahead and leave. Yeah, let's go back on the record. I told Mr. Carver he could go ahead and leave. I didn't know how long or if we get it back. I don't know what kind of problems that y'all have as far as Christmas visitation. Are you aware of any problems, Mr. Davenport?
I'm not, Your Honor. So, I mean, not until 3 minutes ago has anything been said to me.
Well, I'm not, Mr. Latham, what is your problem that you have?
Just at our evidentiary hearing, or at our hearing back in
What is the
December of last
problem?
year.
Yeah. What is the problem?
The problem is that there was an agreement as to what the time that Mr. Carver would have with the child, and then that agreement was reneged on. There was no written agreement. There was a commitment that there would be time that would be available.
You need to put it down in writing. You need to put it down in writing and send it over to Mr. Davenport and see if y'all can reach an accord on it. If you can't, you can schedule a hearing.
We'll do that, Judge.
Okay, thank you very much.
Thank you,
Thank you, Your
sir.
Honor.
Have a good afternoon.
Yeah. Okay, Dishon versus Spears. Hello, hello. Yes, sir.
We're here, Judge, with respect to entering a final order in the jury trial that we
You need
had.
to speak up just a little bit.
I said, we're here to enter final
Yeah.
judgment.
Yeah, I'm aware, yeah.
And I submitted a trial order and judgment. The court reviewed it and thereafter set it aside. It had not properly been reviewed by counsel.
Mhm.
So we're here to enter a final order with respect to jury verdict and the application of KRS 364.130 regarding traveling of damage.
Here's my position on that, and I regret that that order was entered in error, causing any confusion. The jury gave you $5,850, and I don't think there's any doubt that you're entitled to recover some court costs. You had court costs of $500 or $600. What was it?
$565, right?
I thought it was 600 something.
It was 565.
Yeah,
We don't
565.
object to that, Robert.
Do what?
We don't object.
Well, I'm going to order that. I don't think the circumstances in this particular case, that there's applicability of treble damages or expert fees. And, but I will make a specific order of that so you can appeal my decision on that. And the reason I don't feel like that is because I believe the jury, after hearing the evidence, indicated that in this particular situation, the defendant came up and offered to enter into a survey situation and was told by the plaintiff that the line was okay. And then subsequently, after the cutting was done, he goes back up and tells the plaintiff where it is. And then the plaintiff comes in and initiates this action here and wants to get treble damages and legal costs. I just don't think that's what the intent of the statute is. I think that timber was cut under color of title. That person believed the line was there, did everything that they could. And this would be, I understand how you feel like it could be interpreted the other way. But I just don't see with the de minimis sort of award, the individual has been compensated for the timber and the court costs involved. And I just don't think anything else is there, and that's gonna be my ruling.
You're not gonna allow any attorney fees?
No, I'm not gonna allow any attorney fees and I'm not gonna allow any expert witness fees. Because I do not believe that this was a torturous sort of cause of representation. Will you submit a proposed order on that, or?
I've got one here, I'll let.
We'll let him review it. We'll enter it. And I note your objection to that, and I might be wrong about it, so.
Well, I did want to get on the record, Judge, at least a summary of my argument here today.
Please go ahead and do that.
Judge, in 2017, the statute was amended. And Kentucky treats the wrongful cutting of timber on somebody, just like Texas treats rustling of cattle. It's pretty severe consequences for cutting someone else's timber, especially if you don't give written notice, you don't have certified mail, and you don't have a written agreement between the parties. Those aspects of this matter have been discovered in the case, talked about, court heard testimony. There was no compliance with the statute concerning notice by certified mail. No compliance with the statute with respect to an agreement between the parties. Now, the statute says regardless of state of mind, it doesn't matter what your state of mind is. If you cut on someone else without giving notice, without having an agreement, you're liable for treble damages in this state. And it's very clear, Your Honor, that was the intent of the legislature in promulgating this statute. So that business about the pink ribbons indicating a particular line, that was for our purposes. That doesn't mean that they had a right not to give us notice by certified mail or have an agreement between the parties. When they fail to do that, you're liable for treble damages in the state, regardless of state of mind. Doesn't matter what your intent is. You cross over that line without certified mail or without an agreement, you're responsible. And they say that, Judge.
Okay, I've heard your argument before. Now you got it on record.
Yeah.
I don't agree with that.
I understand.
Okay, thank you very much.
Thank you, Your Honor.
Thank you, Judge.
Yeah. Kohler versus Kohler.
Good afternoon, Your Honor. This is Abby Vogt for Charlie Kohler. I'm on Zoom.
Morning, Your Honor, or afternoon.
It's almost 3 and it's not the morning.
This matter was to come up for review today.
Yes, Your Honor.
Yes, Your Honor.
What do we have going on there?
So we both successfully finished the depositions of the parties at this point. I believe we are at the tail end of discovery. I know I'm waiting on receiving subpoena responses from Mr. Bertram of the subpoenas that he issued back in the summer. But I think we are ready to hopefully schedule a trial date in this case.
And what are the cases? What are the issues that will go to trial?
Property division.
Pardon?
Property division.
I know, but what are the issues? I'm not gonna sit here and count spoons.
Yes.
I know.
I don't count spoons.
Yes, we've got a bank accounts and a real property.
Your Honor, if I may, I think what we need is a scheduling order with a deadline for filing dispositive motions and then schedule a trial date. Because I think that all of the non-marital tracing claims, which is the huge bulk of the material, it goes back some almost 30-something years. And I think all of the tracing will go out on summary judgment because it fails. It fails for me just as much as it fails for Ms. Volt's client for the same reasons. And I think once we file those motions, the court can narrow this down. This is all non-marital property. and we
I
can,
I don't wanna argue that right now. I wanna see what we're gonna have to try. I understand that's your position and I
Yeah.
respect that. What I need to have is a list of property that is in dispute and a list of property that is not in dispute. And so the list of property that it is in dispute can be the subject of dispositive motions and tracing and that sort of thing.
correct.
Then I can, but it would appear to me that if there are not too many of those things, it would be a better source of judicial economy of those things that are in dispute to go ahead and take proof on them, rather than just have dispositive motions and then have to deal with it again. If there aren't too many of them, surely it's something that we can get down that we can do in a day or so, if we give a full day to it.
I think a day, absolutely.
So,
I think
Mr. I understand what you're saying, and you could very well be right, but there's very little difference between a dispositive motion and a ruling at a bench trial, I think, you know.
Yeah, but I'm thinking, Your Honor, that based on, most of the summary judgment motion would be based solely on the depositions the party just gave, and those are back.
Well, that's
And
okay.
I think it will take out a huge hunk of the case.
I'm all for that, but
Mhm.
the thing about it is if we go ahead and do the whole trial, if we have dispositive motions, we'll have an appealable issue there, and then it could be followed up with other issues if there's some remaining issues to be done. What I'm saying, if it's not too time consuming, you can make those dispositive motions after we take some evidence, if you follow what I'm saying.
True.
I'll let y'all take a look at it. I'd like by the December, we have a December 18th rule day. If y'all would have a trial, kind of a trial, I don't know where you listened to the case right before this, but kind of have a trial brief on the issues that the property that is to be divided and any kind of dispositive motions about those sort of things. So I have some idea. Are all evaluations done? Or are you going to reserve your evaluations, Mr. Bertram, until after your camera went off there?
I'm sorry, Your Honor, if, hold on. Am I back?
There you go. Yeah. So y'all, if the attorneys will get together on this thing and get me a trial, and I can sentence a trial within 4 or 5 weeks. That's no problem. There are no expert witnesses or anything. Is that right?
At this point,
No.
no, I don't believe there will be any.
Well, it's where you're at that point where you tell me, because once we cast this point, it's a point of no return, you know, because we got to get this ready. So y'all get together and get a list of property and some tracing that you have on it or whatever, and we'll see what we have to decide. And then, of course, Mr. Bertram, I think it would be very helpful if you intertwined in that list, you know, in your position on why it is marital property. And Ms. What you could say why it is marital property, and then I would know what issues I have to decide. So I'll have a little guidance when we try it. You understand? I'm not trying to practice your case for you. I'm just trying to get my arms around it. Sometimes it's hard to get your arms around these things when you have a vast universe and things, you know. Okay, well, thank y'all very much. And
Yep. The December 18th date, Your Honor, I have a conflict. I've got dental surgery scheduled for that day, unfortunately, again.
well, that's the rule day that we have in here. Let me look on my calendar and see if if you're gonna do this Zoom stuff, it's just as easy to do it in one of the other counties as it is here, I guess.
Yes.
Let me see what. We will be in December the 4th. We will be in Clinton County, and December the 15th, we will be in Monroe County. So you can pick either one of those days you like.
I will say, Your Honor, I don't think December 4th would work for me, just given how.
About the 15th.
The 15th is usually Jefferson County. Oh no, I have a hearing on the 15th. So the 18th does work for me.
Is your hearing all day?
It's at least the half of the day. It starts at 1 and then it'll go for the rest of the day. And
No,
it's in Jefferson County.
Well, that's 12 here. Well, then I have on
I hate to say it just because I hate to keep on pushing it off, but I think just given the length of the party's relationship and just how intertwined everything is, I mean, I think I'd be okay with a January date, if the 18th date does not work for Mr. Bertram.
January looks a lot better for me.
Okay, well, let's, January the 22nd.
I am wide open on the 22nd, so that should work for us.
No, no, the 22nd is what we're gonna do is these trial briefs are gonna get to me, then we'll set a trial shortly thereafter. Okay, so that's.
Okay. January 22nd is fine.
Okay, January 22nd for the trial brief things, okay?
All right.
Thank
you,
y'all.
Your Honor.
Yeah, thank you.
Thank you. Have a good day.
Happy Thanksgiving to you. Cole versus Gray. Mr. Cross still here? Was he in?
I believe he left, Judge.
Yeah, maybe he's not involved with.
He quit.
Yeah, okay. I see that. Gary Little filed this motion, is that correct?
Well, there was an order done last month. It said that the plaintiff should have until November 20th to present Mr. Little a cashier's check payable to their attorney for the sum of $170,000.
Yeah, I remember that now. Is that done?
Nothing's been filed since then. He had called one up and needed to be here. I told him nothing had been filed.
Did you pay him the money and everything?
They picked up the money and signed a deed according to the bank.
You may be on your way rejoicing. Okay? Okay, thank you very much. River Valley Credit versus Lisa Branham.
Good afternoon, Judge. Morgan Wiggins for River Valley.
Hello.
Good afternoon, Judge. I'm appearing on behalf of Mr. Hurt. I'm simply here to request a new day for Mr. Hurt. The December motion date, he was unavailable for today.
Your Honor, I would just point out that no response has been filed.
Yes, he says that
Speak up a little bit.
He said, he had informed me a summary judgment had been filed and he is getting a response to the summary judgment.
All right, and are you representing to me that Mr. Hurt says he has some valid defense to the motion for summary judgment?
That is what Mr. Hurt has discussed with me, yes. He says, he had a scheduling conflict.
I'm not worried about a scheduling conflict. I accept that you say that. But I think when we get to this time of year, things get a little dicey as far as scheduling and rescheduling things. The Clinton motion day is December the 4th. I want the response to this motion for summary judgment filed with counsel within 5 business days from today. I'm not going to make counsel wait till the next rule day. I would do the same thing for the plaintiff if there was a motion and they made, representation that there was a valid defense. So we will hear this motion for summary judgment in Clinton County on December the 4th.
Thank you.
And if nothing has been filed by that, and any kind of testimony that needs to be given on that to validate this response. So this response motion summary judgment should be filed by the 26th. And that way council will give you time to file any kind of written response to that if you want, okay?
Thank you, Judge.
Thank y'all very much.
And to obtain the Zoom link, I'm assuming I need to reach out to Clinton Circuit Clerk for that.
No, you reach my office again.
Okay, thank you, Judge.
My staff lawyer does all the Zooming around here. Okay. Thank y'all very much. Carmen versus Warner.
Your wife, Mr. Roderick, he is on the Zoom there. He lives in Mississippi, which is why it's.
Yeah. Hello. Let me know just a second here. We've got a hearing scheduled for today, is that correct?
Correct.
Okay. And what witnesses are you going to call?
So based on the guardian ad litem's report, I would like to take testimony from the daughter. My motion was from the enforcement of the visitation that was set. So I don't think it's really in dispute. The visitation hasn't been occurring. So
That'd be true.
So I think the primary issue is
The best interest of the child.
yes. So that not being brought by me, I guess, I'd certainly have questions about the child as to whether it's in their best interest not to have the visits, but.
You don't have an attorney yet?
No, Your Honor.
You know,
Why is that?
It's just not financially possible for me right now. I work as a waitress, so.
yeah, I don't mind this.
Is the child here?
She is.
How old is she now?
She's 16.
Okay, well, we'll have to put this at the end of the docket so we make sure we have some privacy involved. Okay. Okay, Ms. White, we're gonna put this at the end of the docket here, which is not too long from now.
Okay.
Guess we're already there, aren't we? Okay. Let's, get the DVO, I get over here. DVO docket is set at 2, and it's 2 now. Thrasher versus Thrasher. He's deceased. He is deceased. So it would expire. Pritzker versus Pritzker.
He's in zone, she's in person.